The following is a local resident producer's program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Media Services, the City of Oshkosh, or Time Warner Cable.
The People's Law School is a program produced by the Wisconsin Association for Justice. The Wisconsin Association for Justice, WAJ, is an organization comprised of over 900 consumer advocate attorneys across Wisconsin. WAJ's primary function is to protect the rights of injured Wisconsin consumers and to preserve the civil justice system, including the right to a jury trial. WAJ champions the cause of those who deserve justice for injury to person, property, or civil rights. WAJ also promotes the public good through efforts to secure safer products, a safer workplace, a cleaner environment, and quality health care. WAJ works to educate the public on the importance of the civil justice system. As part of its educational program, WAJ produced the People's Law School, designed to remind the public about its legal rights and our legal system. This program is about powerful corporate interests using political contributions and propaganda to influence consumers' rights. Thank you for joining us to learn about Wisconsin's legal system. I'm George Curtis. Welcome to the People's Law School, brought to you by the Wisconsin Association for Justice, which is an association of people who represent injured people, mostly in tort cases. Many of you may not know exactly what is meant by a tort case, so we've got the person to tell you that. His name is Ed Vogel, and he's the president of the Wisconsin Academy of Trial Lawyers at this time.
Thank you, George.
What is a tort case?
A tort case, as most lawyers understand it, involves either intentional or, more likely, negligent conduct, where one person is saying that they were damaged or injured because of the conduct of another.
Now, it's a civil case. It's not a criminal case, even though it may result from the same behavior.
Exactly right. And when we talk about torts in our court system, what we're talking about is a civil action claiming some type of damage that was caused by negligence or intentional conduct of another person.
So some examples would be if I go to a drugstore and I'm given the wrong medicine and it causes me to be sick or blind. I buy a product that is dangerous, that isn't properly guarded. An auto accident, a plane crash, professional negligence, a mistake by a doctor or a lawyer or an abstractor. It can be a real gamut of kinds of things. It's basically a non-contractual right that's been invaded.
Yeah, basically in all of those examples that you gave, which are excellent descriptions of what a tort case is, what we're measuring is the conduct of another person in a variety of different settings. For instance, in an automobile case, we're measuring the conduct of the drivers who were involved in a motor vehicle collision. And sometimes we look to the laws that apply to the conduct of drivers on the road and say, did somebody fail to yield for a sign or a light, or did somebody fail to keep good attention when they were driving? In some of the other examples that you gave, more likely when it's a doctor or another professional, we're measuring their conduct against what would be expected in their field.
And so if we perform as a driver, for example, and our behavior falls below the standard of care, we don't wear our glasses and we're required to, or we're intoxicated, or we're over-medicated, or we're careless, or we run a stop sign, we have then breached our duty to our fellow highway users, and so we might be liable then for the damage we've caused.
Precisely correct. We owe a duty to every other person to act with reasonable care, which means that when we're driving on the highway, for instance, we're supposed to drive not in an intoxicated state. We're supposed to follow the rules of the road in terms of the speed limits and the signs and respecting other people's rights to use the highway. And when we are negligent, for instance, in violating those rights, there can be both criminal and civil consequences to our actions. But a tort deals with those civil consequences.
And because we know we're not perfect on the highway or anywhere else, we can insure our negligence by buying insurance, casualty insurance, and we have it on our cars. We have it on our premises in case somebody's injured coming to our home. If we are pilots, we would have it there as well. If we're manufacturers of products for consumers, we can have product liability insurance. And so in our system, if we think we might be at fault causing injury, we can insure quite reasonably so that we don't lose all of our assets if we cause somebody an injury. And we're a fault state. What does that mean?
The law in Wisconsin is what's called a modified comparative fault jurisdiction, which means that the fault of anybody, for instance, in a civil case, is compared with the fault of another person or other people when we're talking about a civil claim. So you're precisely correct in the sense that people can insure themselves, and specifically some required insurance for automobiles or other aspects of their life with homeowners policies. But liability insurance protects people in the event of a negligent conduct causing an accident or injury to another person, where you purchase a policy, you pay a premium for a certain level of coverage, and then if in fact you cause injury or damage to another people, you are protected by whatever amount of coverage for liability that you purchased.
And of course, under that comparative negligence law, we can't collect from somebody who wasn't at least as negligent or more negligent than we were if we were a victim. And we can't really collect at all if we were the most at fault in causing the injury. So in addition to compensation coming from the person or company that's responsible for the injury, it encourages safe behavior, because unsafe behavior is not rewarded, it's punished.
Unsafe behavior, and particularly in the context of automobile accidents, causes a tremendous amount of damage statewide and nationally, from the standpoint, George, that when somebody is involved in an auto accident, the reason it's called an accident is because they don't get to prepare or plan for that event. And they're caused in an accident, and there are obviously varying degrees of injury, from no injury to devastating injuries, and sometimes, unfortunately, even death. And what happens in those circumstances is that this person who becomes injured may incur substantial medical expenses, or may be missing work, or unable to provide for their family in the way that they had previously done. So it's important when these accidents occur that there is some investigation into the opportunities or options for how do I make it through these next several weeks, months, or years, given the losses that I just sustained.
And how do you get a lawyer? We know the insurance companies, the manufacturers, they have enough money that they have lawyers on retainer that they can pay by the hour. But how does the individual who was just hurt, can't work, lost their car, has medical bills, how do they get a lawyer?
The individual that sustains damages, for instance, in an auto collision, has the ability to, either by way of advertising or reputation or knowing somebody, to select a lawyer who practices in the area of personal injury, for instance, to assist them in, number one, investigating their claim, number two, answering their questions, and number three, most importantly, helping them through the process so that they have an advocate. They have somebody in their corner to assure them that at the end of the day that their rights were protected.
That's called a contingency fee, and you and I between us have seen thousands of them. And what that really means is that a lawyer agrees to represent the victim, do the investigation, purchase the medical records, pay the filing fee, pay the court reporters, pay the mediator, and run the risk of not being paid if they don't win.
The concept of a contingency fee is just as you've explained, which is that an injured person who's already suffered perhaps significant damages can come into a lawyer and make an agreement with that lawyer that you will help me recover my damages, and I won't have to pay you anything unless you, Mr. or Mrs. Lawyer, are successful with my case. And if you're not successful with my case, then I don't owe you a cent.
Well, I'm glad that's why Ed Vopal and I are doing that kind of work, and sometimes we don't get paid, do we?
Well, hopefully not very often, because that means that our clients are not getting their losses reimbursed.
Thanks for your thoughtful testimony today.
Thank
We'll
you.
be right back.
An 81-year-old woman has been awarded $2.9 million after she sued McDonald's.
It wasn't like the McDonald's employee took the coffee, threw it on her.
Who brings these frivolous lawsuits?
All kinds of people that are jackpot justice oriented.
The media in corporate America did a masterful job. Mrs. Liebeck became a joke.
Businesses use a number of devices to keep the public out of the courts.
In my line of work, you got to keep repeating things over and over and over again for the truth to sink in, to kind of catapult the propaganda.
I was burned so severely that they didn't think I would live.
Are you going to show me the burns? What?
Yes, if I saw injuries like that, I would definitely take a different view of it.
She was drugged. She was raped, gang raped. She had to have reconstructive surgery, sir.
Ms. Jones has had her day in court.
4 years to fight to get in court is not a day in court.
The Appeal was a book I published. It's completely fiction, and it's completely true. It's a story of the purchasing of a Supreme Court seat in Mississippi.
It's a good payoff. You put money in a judicial race, it can have literally $1 million impact on your company.
The U.S. Chamber mounted a very, very large and expensive campaign against me.
When you're pregnant with twins, it's really important to determine how many placentas. When I went in, it should have been immediately followed up with an ultrasound.
You just want to change what happened, knowing that it was preventable.
Go to court and to sue, you have to go through a lot of trouble to do it. It affects your life. You're going to be attacked in all kinds of ways. Going to court to gain justice is heroic.
Welcome back to the People's Law School. I'm George Curtis, and we've got Ed here, who is going to help us with another segment of this particular show, because we're talking about something that he and his firm are probably the leaders in the state in fighting for injured people. He's with Habush, and Rotier, and I've personally known Bob Habush for more years than I'm going to admit, but I think it's more than 50, and that firm has done as much as any firm in representing individuals who were injured on contingent fees and fighting the battles against attorneys that are very good attorneys, that are retained by insurance companies and retained by corporations, and sometimes it's an uphill battle. And yet we are about the only chance that injured people have to get counsel, because they can't afford to come in with a $30,000, $40,000 retainer and get us to represent them. That's been your experience too, hasn't it, Ed?
Yes, it has, George, and thank you for the very kind introduction. But yes, firms like mine and yours who open up our doors to help victims of negligence to recover their losses and to try to make them whole is what our business is about.
And of course, our battle isn't just in the courtroom. It's sometimes in the legislature, because there are many special interests that want to limit the rights of victims. And often it's in the newspapers and on the television. It's the battle for understanding among the public, because what we do and what really happens to victims of torts and other misbehavior is not very well understood. I don't know how many times I have had people come in my office and say, well, it's not like I want $2.7 million for spilling hot coffee. I'm really hurt. And what, of course, they're talking about is the McDonald's case. That's really a controversial case that has been totally abused in terms of propaganda, and most people don't have a clue what really happened there. Maybe you can help us.
Certainly, the Stella Liebeck case, or the McDonald's case, originated from a 1994 incident where Miss Liebeck was a front seat passenger in her grandson's car in Albuquerque, New Mexico. And on the way home from the airport, they stop at a McDonald's drive-thru, and Miss Liebeck orders a cup of McDonald's coffee. And what happens in actuality, George, in that case is that the grandson, because his car didn't have any cup holders available, pulls into a parking stall to allow his grandmother to open up her cup and add her cream or sugar, whatever she was going to put in it. And upon opening up her cup, the coffee spilled onto her lap, causing very severe third-degree burns, which required skin grafting.
Now, that's the beginning of the story. Obviously, that was hot coffee. But what happened next?
What happened next is that Miss Liebeck and her family attempted to gain some compensation for her losses, the medical bills that she incurred. And she went to the people who were in charge of contacting her for McDonald's and said, "Would you assist me in paying my medical expenses?" And that didn't work out for her. So she ultimately, as we previously discussed, sought the advice and counsel of a lawyer to help her get through the process. And that lawyer investigated the case and ultimately started a lawsuit against the corporation, which actually proceeded to a trial.
And it proceeded to a trial because the corporation, McDonald's, was unwilling to settle. There were settlement efforts and offers made by the plaintiffs that were quite modest, as I recall.
That's correct. At one point, I think there was an offer to resolve the case in the $20,000s of dollars, and there was an offer by the corporation to settle the case for $800. Prior to trial, a mediator recommended settling the claim for approximately $225,000, which was refused.
But the plaintiffs' counsel presented some interesting evidence to the jury, so the jury saw it differently. Tell us.
Yeah, the jury was able to see that prior to Miss Liebeck's incident, there were approximately 700 reported claims to the corporation of similar hot coffee type incidents, not all as significant as hers, but similar incidents where the temperature of their coffee was an issue. And what the jurors learned through the course of the trial is that McDonald's had a policy of keeping their coffee between 180 to 190 degrees, which was above what the industry standard called for, according to the evidence at trial.
Not only that, this is a food, and it would be dangerous to drink it at that temperature.
Yeah, I don't think that there is any question but that a liquid at that temperature, if consumed, would cause harm to a person who consumed it. And I think that that was an issue that was discussed at length in the trial.
Well, fast forward. What did the jury do, and what happened after that?
The jury took a look at the case and awarded Miss Liebeck $200,000 for her general damages, including her medical expenses and pain and suffering. But they also found her to be 20% contributorily negligent, or 20% at fault, so that was reduced to $160,000. The jury was asked also to contemplate and decide whether punitive damages were appropriate in this case because of the corporation's conduct. And what they determined ultimately was that 2 days' worth of coffee sales was an appropriate amount to consider and to award, which was $2.7 million. The judge subsequently, after the verdict was returned, reduced that to $480,000.
So the jury verdict was based on some very real numbers and based on the fact that McDonald's had been told at least 700 times previously, your coffee is too hot and it's dangerous.
According to the evidence at trial, that's what the jury got to consider, is the reports of previous encounters with the hot liquid, and then the specifics of Miss Liebeck's case.
So I would say justice was done. I understand that the court did reduce the verdict. She certainly wasn't overpaid in any event, but that wasn't the end of the case. What's happened to that McDonald's case in our country since then?
After the verdict was rendered, the case and the verdict took on a life of its own. And the report of the verdict, publicly and nationally, became distorted to the extent that there was a public relations campaign to use that particular case, not truthfully, but use that particular case to demonstrate the need for what people refer to as tort reform, saying that how can a spilled cup of coffee, without discussing the true facts of the claim, cause a jury to award millions of dollars worth of damages. And after that verdict, successfully, across the nation, public relations people were able to use those facts in not facts, but use what looked like to be the facts of that case in a way that tried to persuade people that there was something wrong with that verdict, and because of that verdict, the legal system was broken and needed to be fixed.
We're going to have to take a break, and we're going to find out that the McDonald's case still has a life of its own. We'll be right back. Welcome back. The name of the show is The People's Law School, and it's brought to you by the Wisconsin Association for Justice. This is a group of primarily trial lawyers who represent injured people in our civil justice system here in the state of Wisconsin. Our guest today is Heath Straka. Welcome to the show.
Thanks.
You're a litigator out of Madison, Wisconsin, but really your firm has a statewide practice. I've known of that firm for a long, long time. And pretty much you're representing individuals and you're fighting against corporations and insurance companies trying to get some justice. And most of this is presenting a case to a jury and having a jury decide what's right. But unfortunately, the jury's decision isn't always left alone. We've got something called caps on jury awards sometimes. Explain that to us.
The caps on damages in Wisconsin are in place in several different areas of law. The most prominent is probably in medical malpractice cases, where there's a cap of $750,000 for non-economic damages. That is, the pain and suffering type damages that someone might incur. If a jury comes back with an award far in excess of that, the judge has no choice but, after the jury has decided, to knock it down to that number.
Well, I think that there are multiple areas where we face caps. For example, in suits against municipalities, the issue is what kind of a county vehicle was on the road. If it's a certain kind of county vehicle, there's a $25,000 cap. Another kind of a county or state vehicle, there's a $50,000 cap. Still another, there might be a $250,000 cap. So that if the victim is a victim of negligence and fault by municipal or government employees, they may have a $2 million injury and get a $2 million verdict, but only get $25,000 or $50,000.
Exactly. I mean, the right to a jury trial, as you know, George, is guaranteed by the 7th Amendment. The jury is supposed to be the ultimate decider on issues, and damages is one of those. But unfortunately, there are several statutes that strip away what a jury might have done in a case, and it takes away a person's right to fight against a corporation, a municipality, and to be fully and fairly compensated for their injury.
Now, where do those caps come from?
The state legislature.
And where does the state legislature get the idea that certain people or certain corporations are more equal than others and are entitled to a cap?
Well, unfortunately, certain parts of the legislature have said that there should be caps for a variety of reasons that aren't necessarily true. Again, to go back to the medical malpractice case, they said caps were inherently necessary because there was so many medical malpractice cases being filed and jurors were running amok. Well, in fact, the number of cases being filed has gone down drastically over the last 15 years.
And the number of successful medical malpractice cases is in a time